My Lords, two short points from this morning, one very short. There's been a little discussion about what's been called plot one. I'm asked to point out there is no evidence about the contents of the conveyance of plot one. It's self-evident. It doesn't necessarily follow that all the different conveyances that relate to the different plots are the same. I mean, the two that we've got are, but comparable. You can't necessarily assume that. Secondly, and perhaps more importantly, I am definitely pursuing what I've described as my fallback point, although, as rightly pointed out by Lord Justice Nugee, it has a relatively recent provenance. What we can do is we can apply the facts of this case to the language of paragraph 11, particularly the end of it. Because the facts of this case are, we've got a detached house that is proposed to be demolished.
Sorry, before I'd like to follow you through this
right.
train of reasoning, but let's suppose we had a ground of appeal that said the judge was wrong not to find X.
Yeah.
What is it that you're asking us to accept by way of a critique of the judges?
Yes, he was wrong not to find that the proposed work, the subject matter of the, I think it's called DOM, yes, deed of modification, which is the demolition of the house and the replacement with a block of 9 flats, was not a breach of the, or rather not actionable by my client.
Strictly would not be, were the DOM to be executed.
Yes, the DOM that we've got in the core bundle is at page 104, and I probably should, because this is all part of the factual matrix. There are recitals in that, beginning on page 104, which begin by referring to the conveyance of 444, and then if you go over onto page 105 and you get to recital 6, the owner has requested the foundation to modify the covenants and stipulations and to give consent under the stipulations to permit alterations in the erection on and use of the property for no more than 9 residential apartments and associated groundworks, etc., in accordance with the planning permission, and then it identifies the planning permission. So the issue with which this court is actually concerned is whether if this deed of modification is entered into, whether it would be permissible within the terms of paragraph 11.
I'm not understanding this, because that's exactly what the declaration
it
says. I mean, all you've done is restated a proposition that the declaration that was made by the second judge but not by the first was wrong.
Yes.
I'm not understanding how the fallback point is being defined in order to distinguish itself from your main case.
Well, it would be defined, well, since it was pointed out that the fallback case isn't identified in terms in the skeleton argument that I put in for the purposes of this appeal, it's obviously appropriate that the learned friend would know what I'm saying. And what I'm essentially saying is that a deed of modification in the terms that I was reading, that, in other words, that permits the demolition of the house and the building of the 9 flats, is outside paragraph 11, and perhaps the additional point is that it would involve, it's more that whatever paragraph 11 permits, it's more than that is permitted, because it involves putting a red line through one of the key covenants.
Can we just start from what I do understand your case to be? If we look at the order, the judge's order, paragraph 53, under point C.
Yes.
This is the legal conclusion to which you object.
That's right. Yes. So,
right.
So
I'm just saying that it seems to me that you've done no more than restate your objection to that conclusion. but I may have understood.
No, it's
misunderstood.
another route to exactly. I'm not seeking any different relief.
I understand that,
from
but all you've done so far is that you said that the judge was wrong not to find that the subject matter of the DOM involving demolition and replacement of 9 flats was ...
But if the second half of paragraph 11 has any meaning to it, separate meaning from that which is addressed in the earlier part, then that meaning doesn't catch the works, the subject of the DOM.
All right, well, I don't want to press on. I just say for what it's worth that I haven't understood the difference between the fallback case and the main case. But it may be that my lords are better off than I am.
Can I see if I've understood? If we look at your grounds of appeal,
Yes.
the first ground of appeal on page 17, called bundle, says the judge was wrong in his construction. And then you say, and in his decision, that the charity had power to grant a retrospective release of covenants incorporated in conveyances of plots on the estate that had already been sold. And at the end of that part of your grounds of appeal, paragraph 5, you say the judge should have dismissed the appeal from the master and approved the master's reasoning. Now, as I understand that, that's what you now say is your primary case, which is that the second bit of clause 11 simply doesn't apply at all to plots already conveyed. So it doesn't apply at all, in your case, to plot 444.
Yeah.
And your secondary or fallback case is to say, even if that's wrong, and the second part of clause 11 does apply to plots previously sold, so that the charity can allow a departure from the stipulations contained in the conveyance of 444. There's a limit to what they can do by way of allowing a departure, and whatever that limit is, it doesn't extend to the demolition of the existing house and its replacement with a block of flats as per the DOM. That's a different argument of construction, which says you can allow a departure, but not a radical one, effectively.
Yes.
Have I understood that correctly?
You have understood it more than correctly, my lord. Yes. You've articulated it far better, without wishing to be unctuous.
But your combined efforts have got me there. Thank you very much.
I only wanted to add that in the evaluation of whether what the charity is permitted to do and whether it's going too far by the DOM, it's important to note that what it would be otherwise sanctioning is redlining or deleting one of the key covenants in the conveyance. This, in other words, isn't some tinkering exercise of the kind that I discussed with, I think, Lord Justice Peter Jackson, because what it would involve is, and I'm going back to the language of the covenants, yes, it's paragraph 7, which of course is the very subject. It would be effectively redlining paragraph 7, because that talks about detached dwelling house and other, it would be removing that effectively.
On this thesis, would the defence to counterclaim need amending as well? I think it's page 147 for the relevant bit. As I understand it, when you get there, the construction for which you're contending is that set out in paragraph 8.2, little 1.
Yes, so your lordship is telling me that my existing pleading is doesn't extend to raising this point.
That looks to me to be right. I think here you pin your colours to the mast of your primary argument, don't you?
I think in this respect, I would take some solace from the fact that the whole backdrop to this litigation isn't a trial. The whole backdrop to this is that after pleadings, the defendants made an application for summary judgment.
Yes.
And so effectively, within the aegis, as I would contend, of an application for summary judgment, I'm not bound by the pleadings, because we're not having a trial in accordance with the pleadings. We're having a trial as to whether there is an issue. Now, of course, it's open to the court when dealing with summary judgment to decide the case one way or the other. Sometimes it decides there's an arguable point in the middle, but in deciding whether there's to be a trial or not, it isn't bound, I would submit, by the language of the pleadings. And indeed, for example, imagine that this argument that I propounded today was not propounded by me for the first time, but one of your lordships was to be looking at, and just perhaps hypothesising was to say, what about this? I might then say, well, that's a good idea. I will adopt that as my fallback. There's nothing to prevent me doing that, because it's a summary judgment case. It would be wholly wrong for my client to be cut out if it. What we are dealing here with are issues of construction or issues of law. Against a backdrop, that's why I wanted to emphasise the look at the DOM and focus on the language of the covenant.
That's a slightly different submission. That would lead to the consequence that if we were with you on your secondary case but not your primary case, we should allow the appeal, set aside the summary judgment, and then allow you to go to trial, no doubt with amended pleadings.
Exactly.
And so on.
Exactly.
Whereas I had understood you before to say that we could ourselves take the view, if we were persuaded of your secondary case, that the proposed works were so radical a departure that on any view they must, as a matter of construction, fall outside the scope of the second limb of paragraph 11. And I'm now not sure what it is you're asking us to do if that's where we end up.
Well, I would suggest that the safer haven is via the right procedural route, which is recognising that the defendants initiated this process by summary judgment, and all along the deputy master and then the judge and now yourselves are all considering the matter against the backdrop of a summary judgment application.
So we should what do?
So you decide on the arguments that you have heard. One, whether the judge was right, because if the judge was right, then end of story. Two, whether the deputy master was right, but the result will be the other way round. Or three, that I'm right on this additional argument, and if I'm right and you don't need any more evidence, because the evidence is there as to the planning permission and the deed of modification, if you don't need any more evidence, then you gain. Can you dismiss the appeal? Sorry, allow the appeal.
I see. But if we think that it's a matter that should be tried, then we send it back for trial.
Yeah, yeah.
I see. Thank you.
So that was the second of the points that I held over or came over from this morning. And that leaves the final matter that I wanted to address, which is in my learned friend's skeleton argument, and it's paragraph 37 of the skeleton argument, which is core bundle, page 47. And he said, the judge did not rely on Maynard and Payne in coming to his conclusion. Maynard and Payne contained a reserved right in identical terms in a building scheme. And then he carries on and he says the case supports the judge's reasoning. We say, and I'll show this in a moment, Maynard, the right is not identical. The factual and legal context is very different. And there was, as far as I can tell, but I'll be showing the lordships, no argument as to the extent of the right, whatever it was, in that case. And it's important to look at the decision in Maynard and Payne because testimony to my learned friend that he unearthed this case in arguments at first instance. Could I take you to it, which is in the Bundle of Authorities, tab 1, page 3, and I'm going to spend just a moment or two going through the facts, because they're in the usual way in these quite older cases. You get the facts from the earlier part, and then you get the judgment, which is quite short. So, and it's all about a Mr. Webb and a consent that he gave. So at the bottom of page 3, 1889, Mr. Webb owned a freehold building estate at Bexhill, known as the Egerton Estate, and he put it up for sale in lots by public auction. All the lots were not sold. Then there's a deed on October 17, 1895, where Webb and his mortgagee, in consideration of a price, sold and conveyed to the plaintiff 6 pieces of land forming part of the Egerton Estate, and they had numbers 753 to 758. So you have to keep 753 in mind. And then if you drop down page 4, near the foot of the page, the stipulations in the second schedule to the deed were 17, and were also identical to those used at the auction sales. And then over the page, you've got various stipulations. If you go down to number 11, shops, no trade, business or manufacture of any kind is to be carried on except those marked shop lots. And then 16, rights reserved. This is what's said to be the identical right. The vendor, and you'll see there's an argument about vendor, reserves the right of allowing a departure from these stipulations in any one or more cases. Then there's a provision about mutual covenants in 17, which is part of the creation of the letting scheme. Then you'll see none of the lots conveyed by the deed were shop lots. Then there's another deed with the plaintiff of the one part and Mr. Whitechurch of the other part. And then there's a recital of the money, and then that conveyed the land comprising the 6 lots, 753 to 758, to G. Whitechurch in fee simple. And then I'm cutting out a bit of that, and then there's references to that. And then over the page, middle of the page, in 1908, G. Whitechurch died, and then in a deed in 1910, between the executors of Mr. Whitechurch, called the vendors, hereinafter called the purchasers of the second part, and Mr. Webb of the third part, and various other persons, conveyed a piece of land, number 753. And then, if you look a bit further down, about 6 lines up, Webb, in consideration of £50 paid to him, agreed and consented that the sub-purchasers and the survivor, their heirs and assigns, should, notwithstanding anything in the aforesaid stipulations contained, be at liberty to erect a church on the land, or if the land wasn't required for that purpose, which happened, to erect thereon shop buildings or other premises, and use the land as if the same had been marked shop lots in the plan on the deed, providing that the agreement and consent of Webb should not be construed as authorising said piece of land or any part thereof or any building erected thereon for any noisome, offensive purpose, etc. Then if you drop down middle of the page, April 1913, the defendant Payne commenced to build and in the following June completed the erection of a motor garage on lot 753. And there was a deed demising the same for a term of years to the defendant Grime, who then started to carry on the business of a motor garage proprietor. The plaintiff commenced this action in September 1913, and he alleged that the erection of the garage was a breach of the stipulations in the deed going back to 1898, and that the carrying on of the business of the motor garage was a breach of the stipulations, etc., etc. And then over the page, so you've got 2 defendants going here. At the top of the page, first main paragraph, the defendant Payne by his defence, and then he alleges his various things. If you drop down 2, 4, 6, 8, 10 lines, he alleged that the word vendor, wherever used in the stipulations contained in the deed of 1898, and in particular, 5th, 8th and 6th deed, meant Webb and not the plaintiff. And he referred to various deeds, and that the business of the motor garage proprietor carried on the same premises by the defendant Grime was authorised by the consent of Webb in a deed of 1910. And then if you drop down, near the bottom of the page, the defence of Grime was to the same effect. This was a trial, so evidence was given on behalf of the plaintiffs for the alleged noise and nuisance. The case was decided on the preliminary point mentioned below. Mr. Webb, who was called on behalf of the defendants, stated when the plans for the garage were first submitted to him, he didn't object if the adjoining owners didn't object, but he afterwards gave his unqualified consent to the erection of the garage, and he still authorised it and consented to the business carried on there. Then you've got the counsel for the plaintiff, and And they start off by saying it's a building scheme over a defined area, and then they refer to various provisions about that. And then they say about 15 lines down, the plaintiff is still the owner of some lots near to the garage. He's entitled to the benefit of the covenants, and there's no such change in the character of the neighbourhood. The covenant in the deed of 1895 clearly establishes a building scheme between Webb and Mayor as to the Edgerton Park estate, and the vendor in that deed means Webb. Then there are various other provisions. And then over the page, there is no ambiguity, and the vendor is the person who is selling and conveying. That is Maynor. But if there's no ambiguity, you can look at the surrounding circumstances to construe the deed. I don't think it must mean no, it must mean if there is ambiguity. That lets in the contract between Maynor and Whitchurch, which shows conclusively that Maynor is the vendor. And then the judge comes in with a comment about what you can look at as surrounding circumstances. And then near the foot of the page, counsel for the defendant Payne say similar things. And then if you look to the end of what they say, so over on page 11, the authorities, the last sentence of counsel for Payne, he says, the covenant in effect is not to do something without the consent of Webb. And if we obtain his consent, there's no breach of covenant. And then the judge intervenes, and he says, it seems to me there's a preliminary question on the decision the whole case turns. Mr. Peterson has directed his argument to him. Mr. Peterson was the plaintiff's counsel, and it is this. Assuming everything in favour of the plaintiff in regard to his right to sue and his remedy against the land, the question arises, what's the obligation the owner of the land is bound to fulfil? In the conveyance, defendant Payne's predecessors covenanted with the vendor that he will fulfil the stipulations, and then you turn to the schedule to find out what they are. The stipulations are read as meaning the vendor in them is the grantor of the land to Whitechurch, then of course all the other questions arise. But if on the other hand vendor means Webb, then you have to consider what's the obligation of the covenant. And the obligation of the covenant is the purchaser will fulfil the stipulations, reading in them Webb as the vendor. If so, the action would fail, because the covenant is only to obey the restrictions subject to the licence of Webb. And the licence of Webb having been obtained, there'd be no breach of covenant. This is all the judge, you see by the square brackets, this is all the judge intervening with his comments. And then counsel, no doubt terribly pleased, says, that's the main point of our defence. And if we're right on that point, the plaintiff has no case. But it's said that the power to vary the stipulations applies only to the land retained by the vendor. It may, however, be general and apply both to the land retained and the land conveyed. It's merely a question of construction. By the deed of 1910, to which my predecessors entitled Webb were parties, Webb released my land for business purposes and approved of the plans for the garage. The power to vary is an arbitrary right retained by Webb. It is part of the building scheme, and such a power is valid. And then counsel was stopped, and the counsel for the other tenant didn't get called on, and then there was a short reply, or however long the reply was. And then you've got the judge commenting in a relatively short judgment, and if you go down about, the judge reads the deed and continues. The question is, what was the obligation under the deed in respect of the conditions in the schedule? The land in question has been laid out as a building estate by Mr. Webb. The best way of expressing the equitable view is that taking the obligations of the subsequent owners of parts of the estate subject to such a plan by the adopted in Reed and Biscascarf and other judges, it is a local law, so it just spells out what the law is about a building estate. It is a law by which the land is bound and the rights of the landowners inter se are equal. And then he goes on to make more comments about Mr. Webb, and he says, about 10 lines down, what was effected by the deed was the land was conveyed subject to stipulations set forth in the schedule, which was the local law that had been imposed by the original vendor. Then comes the covenant, which was both with the person who conveyed and also with the owners of the land to whom the stipulations related. Seems to me it's merely a covenant to obey the law of the locality as it stood, and when we examine what that law was, we find it was a law which could be varied at the option of Mr. Webb, the original vendor, who reserved by the 16th condition the right of allowing a departure from any stipulations in any one or more cases. And therefore, there's been no breach of the covenant, and the question of the right of the plaintiff to sue doesn't arise, etc. So the judge picked up the thought that was being developed by one of the counsel and effectively went on to decide on this preliminary question whose consent mattered, and it was Mr. Webb, and he'd actually given evidence that he'd consented, and so the case collapsed or was dismissed. And now the only reference that I see in this case to the right to vary is near the top of page 12, 2, 4, 6 lines down, where they say the power to vary is an arbitrary right retained by Webb. It is part of the building scheme. So the issue that the judge was deciding was it Mr. Webb whose consent was needed, and he decided it was. He was the vendor for these purposes. As far as I can tell, there was no argument as to the scope of the power to release, and the power to release, as I showed you, isn't exactly the same. It's on page 5, it was right 16, so it's obviously a different right against a different backdrop. And
why do you say it's a different right? It's a right to allow. I mean, the language is very similar. Right to allow a departure from stipulations. That's the same as we have, isn't it?
well, it's part of what we have, but the because of course what we've got is well, I'm not going to read it out. You contrast 11 at the bottom of page 160 in the core bundle with the right in 16. So it is a right reserved, but the wording is different, and I'll be explaining why that matters. It was a building scheme case, so you had a situation, everyone was party to the building scheme, and Mr. Webb had this special right which trumped anybody who was on that estate. And so we say that the factual backdrop was different. I don't perceive that there was any argument as to the scope of the right, because in this case, whatever the rights reserved were, the vendor could give consent, and he actually went into the witness box and said, "I've authorised this." So, I perceive this to be a rather different case, and this is where I then go back to Rees and Peters, which I referred to this morning, and the risks that are run in taking out either the same words or similar words from one case and then picking them into a different case. You're probably familiar with that, but if I can just show you tab 9 in the bundle, which is page 142. And Rees and Peters was a case, it was a restrictive covenant case, but it was whether successors in title were entitled to the benefits of the covenant. And if you look in the H1 of the head note, you've got restrictive covenants, covenant for the benefit of the property hereby conveyed, etc. And it's whether the covenant was enforceable by a subsequent purchase. That was the issue. And the Chancellor delivered the first judgment, and on page 146, paragraph 10, there's a little red line. He says, "I prefer the submissions of counsel of Mr. and Mrs. Rees. Issues one of construction of the conveyance in the light of the surrounding circumstances prevailing. Carrying out that exercise, I derive no help from any of the cases cited to us and to which I have referred. Similar phrases in other contexts may bear different meanings." And then the matter was put rather more expansively in the judgment of Sir Stephen Sedley. I might politely invite you to read page 150, where the red line is, because he actually expresses it very clearly.
Court rise, if able.
I'm sorry.
Yes, Mr. Vane, thank you very much. We have your skeleton argument, which has been helpful. And of course, we're aware that you haven't yet focused your submissions in response to the fallback case.
Yes.
But take your own course. And if there are points that we don't feel we need to hear you on, we'll perhaps indicate.
I'm grateful, my lord. On the fallback point, yes, no, I haven't. This is a brand new point. In my submission, it would require both amendment of the grounds of appeal, my learned friend's skeleton argument, and also his reply to defence to counterclaim. Sorry, defence to counterclaim. One point on this is, if I take you to Deputy Master Bowles's judgment, this is page 79 of the core bundle. It's paragraph 71. So my learned friend is correct that what happened was my client applied for summary judgment on the claim.
Yes.
We didn't succeed before Deputy Master Bowles, because Deputy Master Bowles said, I agree with Mr. Warwick's construction of paragraph 11. But Mr. Warwick's client hadn't cross-applied for summary judgment, so it left the position in the parties in a quite a bizarre position. So what the parties did, and that's shown in Deputy Master Bowles' order, is they in effect treated that as the final determination.
And there's a recital in the order.
Yes, because that's where it's dealt with. So therefore, what my learned friend will be doing is in effect reopening the whole trial, and I can take you to an old decision of this is not a dress rehearsal. A trial isn't a dress rehearsal.
I don't think we need that.
No. From what I'll briefly deal. I'll deal with the words departure insofar as I can in my submissions. But what this case is really about is how the court should construe paragraph 11. It's a question of construction. I will come on to it, but in my submission, derogation from grant doesn't apply here. In my skeleton, I referred to Arnold and Britton. I'm not going to take you through Arnold and Britton. But the point that I will take out of that is you're looking at the parties to the contract. The parties to this conveyance were the governors and Mr. Reed, the purchaser. So you're construing this conveyance in October 1947 as those two people are the parties to that conveyance. What my learned friend is trying to get you to do is to construe the conveyance also with Mr. Courtney, who buys number 432 a month later. And in my submission, that's wrong, and not a way to approach how one construes the October 1947 conveyance. Before we get anywhere about arguing about the commercial common purpose or looking at other clauses in the lease, in my submission, the most important thing to look at is the natural and ordinary meanings of the words, and they are clear in paragraph 11. I cannot fault Mr. Justice Miles's reasoning at paragraphs 37 to 47 of his judgment. As I've set out in my skeleton, there are two rights contained in paragraph 11. I was criticised, I think, for bringing up a new way of looking at it, using the words modification or release in my skeleton. That has always been the defendant's position. I could take you to paragraph 3E of the reply to defence at page 151 of the bundle. It's not in the bundle, but the same wording came from my skeleton before Deputy Master Bowles and also Mr. Justice Miles. But it is clear that there are these two rights. And as far as I understand it, it has never really been disputed by either party that the first right is in relation to future dealings. So the first part of that sentence in relation to future disposals, which, for all the reasons given by Mr. Justice Miles, and also in argument today about when we're looking at plot 1 or plot 50, that most of my learned friends' arguments don't work in relation to future disposals. So I think your lordship gave the example of I can have gasworks to the left of me but not gasworks to the right of me. And that is just completely inconsistent with the way that you should construe this conveyance. It is not torrential drafting. It's quite clear, and Mr. Justice Miles sets us out at paragraphs 39 and 40 of his judgment, that the wording, there are two distinct rights. The verb reserve is used twice. The words and also are important. They differentiate between the subject matter of the two parts of the clause. It's quite clear that anyone picking up that document will read it, that the first part is dealing with land that's retained, that's being sold off, and the second part is allowing a departure from the restrictions, the stipulations in the land that's being sold, in the schedule itself. The words to allow a departure from, this can only mean a release or a modification of the current restrictions. It's allowing a departure is allowing someone to move away from something. You've been taken to Maynard and Payne. So in 1914, it seemed that all the parties in that case understood the words allow a departure from to mean exactly this, that you could release a restrictive covenant. And that's some 30 years before this conveyance, I think 33 years. Departure is apt to describe moving away from the restricted covenant at stipulation 7, which is you can't have more than one house on this land. And that is exactly what is happening here. That my client has been, well, if they sign the deed of modification, will be allowed to build more than one house, one detached dwelling house on the property. The reference to them clearly refers to the stipulations in the third schedule. I can't see how it could refer to anything else. My learned friend seems to try and say, no, it refers to the stipulations in the first part of that clause, but that doesn't make any sense. So on the natural and ordinary meaning of the words, it's very clear. So in my submission, you don't even need to get on to considering the commercial common sense or the other relevant provisions, but when you do, that points even further towards the construction that Mr. Justice Miles gave. So one of the examples was in relation to other parts of the third schedule that clearly give the governors a continuing function even where some of the retained land has been sold. That shows the governors want to continue to have this supervisory role. Looking at the other words in the conveyance, I think, my lord, you referred to paragraphs 4 and 5 of the third schedule, if I get those up. Sorry, excuse me, I'm just trying to find it. It's
159.
Thank you. Page 159. It's notable in both paragraphs 4 and 5 that there is more than one restriction as part of the use of by the draftsman. So paragraph 5, for example, you have no trade or business shall be erected on any part of the property, and no, I think it's manufacturer, I can't quite read the version of this.
No manufacturing, mill, gasworks, hospital.
Thank you. I'm very grateful. Then there's a full stop, and then there's another restriction. So it's quite clear that the draftsmen here are more than happy to include more than one restriction in each paragraph of that stipulation, of those stipulations. as Mr. Justice Miles correctly said at paragraphs 50 to 55, this does make commercial common sense. It makes commercial common sense to the two parties to the contract. It makes commercial common sense to Mr. Reed, the purchaser, because he knows that if he wants a release, a departure from any of these stipulations, he just needs to go to the governors to ask for that. He doesn't need to, first of all, find out who's got the benefit of all these covenants. This is not a building scheme. And then, having found out that that's the case, he doesn't need to go to every single one of them and say, please will you give me a release, with the inevitable conclusion that one of them might say no, and therefore hold a veto over it. So it makes complete sense for Mr. Reed in 1947 to agree to paragraph 11 in the way that we suggest it should be agreed. And it makes complete sense for the Whitgift Foundation, or the governors as they then were, to have the control of this release.
How would you find everybody? Would you search the land registry?
I think that's what you would. Yes, that's what you would do. You'd search the land. Well, I don't know what you do in 1947 necessarily. You'd probably have to work it out.
You'd have to start with knowing
who was sold
who everybody was that this Fox's Farm land was sold to. So first you'd need to, and I wonder where you'd get that information from. Then once you'd identified each property, you'd have to go to the land registry and search each individual one to find out when they was transferred.
If they were registered
then you'd
back
have to
in
make a league table of where you were in the
yes.
in order to know who you needed to ask and who you didn't.
Yeah.
And then sometimes you might not find anybody.
I don't suppose you know when registration became mandatory in Croydon.
Unfortunately, I don't. I can ask my learned junior to try and find out for you. I don't off the top of my head.
I mean, there has been land registration in London for quite a long time.
Well, I mean, we could probably, if the office copy entries are in the bundle, it will tell you when these properties were first registered. So that might give you an indication.
Well, I'm looking at page 96 of a supplemental bundle, which is a transfer in 1947, which is headed Land Registration Act.
I think if you look at 92, it seems to be registered on 28th of February 1949.
Yes, so it's probably fair to infer or assume that these properties would have been registered. So yes, you'd go to the land registry and you'd look it all up. That's what you do now. Now you'd spend time on a computer downloading all the relevant office copy entries to find out who's got the benefit of these strict covenants.
Has the registered proprietor always been publicly available information?
Good question.
I have a vague feeling that the price at one time was held back, but that you can always see the proprietor. But I may be wrong about that.
I don't know the answer to that. But I've been at the bar for 20 odd years now, and I remember there's quite a lot of office copy entries that didn't have the price, as my lord says. But I've always seen people's names on it. I'd be surprised if names were held back.
Yes, I mean, also, I'm not. I go on indefinitely about this, but just trying to see the ramifications of your submission. I mean, it might not be that number 400 is owned by owner-occupiers Mr. and Mrs. Jones. It might be held in the Cayman Islands on behalf of somebody.
Yes.
So there it is.
You'd certainly need to be able to work out what the bounds of the estate had been.
Yeah. You need to know, you need to work out what the estate was and who was the most likely person to have the benefit of these covenants.
Yes.
And who was, well, I suspect you'd also take a commercial view as to who was most likely to enforce those covenants as well. But yes, it could be a very easy job on a very, very small plot of land. It could be extremely difficult. But in my submission, it makes complete sense. And an authority in the bundles, is Crest Nicholson McAllister, which is a case really all about annexation. But in this case, at paragraph 48, which is at page 110 of the authorities bundle, if you could read the red-lined starts at H at the bottom of page 110 over to page 111.
Yes.
So there, what Lord Justice Chadwick is saying is exactly what I've just said, which is that this is exactly the sort of thing that someone who's selling off development land would do when you don't have a building scheme. So it is not a surprising commercial outcome, even if you're talking about a charity in 1947. This is, in my estimation, this is exactly what this part of paragraph 11 is getting at.
Anything to say about the submission to which Mr. Warwick was, I think pushed, which was that these words in clause 11 may mean different things if included in a series of transactions over a period of time, depending upon where you were in the batting order.
I struggle with that submission because if you were a developer or if you were selling off plots of land and you had a stock set of conveyances with this, you would expect them all to mean the same thing. You would use different language if you wanted the outcome of a clause.
But from the point of view of the vendor, if that was the case, then the vendor would never know what the same words meant depending upon who it was dealing with. And from the point of view of the purchaser, or the purchaser's successors, they'd never know at all where they sat.
Yes.
If they read decisions of courts about their neighbour's property, they wouldn't necessarily know that they apply to theirs as well.
Yes, I mean the Rees and Peters case, he's right in the sense that what you shouldn't do is take a case that says exactly this and go in a different context and say that must apply here. Maynor and I've never said Maynor and Payne is the exact answer. You are bound to follow it, Deputy Master Bowles, and because that's not the case. What I said with Maynor and Payne was here is a case on in a similar context. But actually, it's a building scheme, so one might take the view that Maynor and Payne was a bit of a surprising decision, given it was a building scheme, allowing someone to have that power. Whereas we're not a building scheme. But all I can take from Maynor and Payne is another judge, in my view, quite rightly has seen similar words in a similar context and has taken the view that's what they mean. They allow a party to allow a departure from the stipulations which have been agreed. And it might be said that Maynor and Payne could assist the court in what departure means, because it seems in Maynor and Payne that in 1914 the word departure was being used as a way to allow modifications or releases from restricted covenants. In my submission, the word departure hasn't changed at all in 100 years. You use it in exactly the same way.
The language is strikingly close, and I wondered at one point whether there was a book of precedents which people had drawn on, but no such research has been.
I've not given evidence, my lord, but I did pop up to the dusty bit in Lincoln's Inn to look at those conveyancing precedents, and it wasn't in there, to my disappointment. Because that would have been a one. Then I could have relied on it and said, there we go. Here's some factual evidence that shows that was in use at the time. But unfortunately, that's not the case.
No, okay.
So my submission, Mr. Justice Miles got it completely correct. He did actually, to some extent. I'm just trying to understand the derogation from grant argument. I think there's two strings to Mr. Warwick's bow, and I think they are, firstly, the way that you interpret this contract is by interpreting it in a way that it doesn't derogate from grant another contract, I think, is being argued. Alternatively, because number 432 receives these the benefit of these covenants with subject to the governor's power to release them, the governors can't act in a way that would derogate from the grant of number 432. I think that's what's being argued, and in my submission, neither of those submissions affect the construction of the covenant in this case. Mr. Justice Miles did deal with this point at paragraph 49 of his judgment, and he gave his reasons in paragraph 50 onwards. The Earl of Plymouth and Rees case at page, well, in particular paragraph 21 at page 262 of the authorities bundle, is in my submission an answer to this. Yes, this was a case about back detectors and the like, but I think it's very, unfair to dismiss this case as a case that doesn't assist this court at all. Paragraph 19 of Lord Justice Lewison's judgment, which starts at page 262, it's quite clear that what Lord Justice Lewison is doing is considering the derogation from grant principle. He says, I begin by considering the derogation from grant principle. And he explains what it means, and he even refers to my learned friends, one of my learned friends' cases, Johnson and Sons and Holland. And he explains that it's not confined to the principal landlord tenant. Paragraph 21 in my submission is the key paragraph. I'll leave you to read that.
Yes.
So the point there is, well, it can't be a derogation from grant if the grant itself includes this reserved right, which is exactly the position here. So the covenant that Mr. Courtney, as the purchaser of 432, has is always subject to the paragraph 11 reservation. So it must follow that it can't be a derogation from grant for the governors to exercise their powers under paragraph 11, because what Mr. Courtney is receiving is subject to the governor's ability to exercise their powers. And then, if we need to go further, I think this was brought out by your lordships this morning, that if there is a derogation from grant, it can only happen if there's a serious interference with the right or the benefit. And here, building 9 flats where you've got planning permission, and I can take you to the planning permission and the planning report, which interestingly has a little diagram of all the surrounding properties, and it goes through them and saying why it doesn't really have any effect on them, and that's the reason they gave planning permission. None of those properties are 432. 432 is about five doors down from 444. So firstly, the derogation grant principle doesn't apply here. Secondly, even if it did apply, there's no evidence before the court that there's a serious interference with 432 or the purpose of the conveyance of 432.
As I understood Mr. Warwick's submissions, it wasn't so much that the exercise of the right in this case would derogate from the grant to Mr. Courtney. It was that the principle that people shouldn't purport to give rights and then take them away, or have the ability to take them away, was relevant to the question of construction and to, I think at that stage, his primary case, that this can't be construed as widely as you want it to be construed, which is a slightly different point.
Yes. The answer to that point, and having got Mr. Warwick having gone through, my friend having gone through all those cases, is where there are clear words, you can take away a benefit. and here there are clear words. So all the cases that put before you, like the banker's bonus case, for example, there weren't clear words. In fact, when I read that, I thought, well, yes, they can change the bonus, but they can't change the 2008 bonus, which is the one which the formula's for. So it depends on the construction of the clause, but for all the reasons that Mr. Justice Miles gave, when you look at the natural ordinary meaning of those clauses, they are very clear.
Right.
I'll just check with my learned junior. So my learned friend has carried out some research. I think it was 1939, compulsory registration.
Thank you.
Yes.
In London.
In Croydon.
In Croydon.
My lord. My lord, unless there's anything else, for all the reasons of my skeleton argument, I ask you that you dismiss the appeal.
Well, can I just ask you this? On Mr. Warwick's secondary case, the new case, you said it would require an amendment to grounds of appeal. Would you oppose an amendment to grounds of appeal?
I'd have to take instructions on that.
Well, I think we should know what it is we're being asked to decide.
I've kind of, I mean, it's always nice having a surprise. However, not necessarily in the Court of Appeal. I'd need to take instructions to know whether I should oppose or not oppose him amending his grounds of appeal to run that argument. My primary submission is the Court of Appeal shouldn't allow that argument to be run, but if you do allow it in, it's not a good argument for all the reasons that I've given, and also I think Mr. Justice Miles does deal with the word departure and what it means in his judgment. And he wasn't being asked, well, let's assume it means what I say it means. Does that still mean that the building out and the plans that you've got planning permission for doesn't fall within the word departure?
I think the point my lord is asking is, I mean, what I've got is, don't let them run it. If they do run it, it's bad. But if it's arguable, ... if we were to think it was an arguable point, you say they need to amend.
I say it needs to amend.
And so what you're being asked is, do you have a position on that?
I'd have to take instructions, but my primary position is you shouldn't allow it in because you'd have to amend both his pleadings and his grounds of appeal, and it's far too late to be doing that now and to be taking the respondent by surprise without me having properly thought through what the consequences of all of that would be.
All right, well, if you get
in circumstances where, as you said at the outset, although this was a summary judgment application, by the end of the Deputy Master's judgment, the parties had agreed to treat it as a trial of the action. Is that right?
Yes.
I understood that correctly.
Yeah.
Well, I think it was after the decision had been made. Everybody realised there was nothing left to argue about, and so therefore the action was put out of its existence.
Yes.
It wasn't ahead of time that everybody agreed that this would be treated as being the trial of the action, was it? It was.
No. What it was is the summary judgment hearing. I failed on the summary judgment. So then, either my learned friend cross applies the summary judgment based on what the Deputy Master had said, or we'd had directions for a trial where you would have thought that a judge of pure judicial comity or by a judgment estoppel would have to find in the same. So it was a completely pointless exercise. So rather than my learned friend applying for summary judgment, we all just treated it as a final.
So you fell on your sword, and when the boot was on the other foot, so did Mr. Warwick.
Yeah.
So I think, for completeness, the only other question is this. Suppose we were persuaded by Mr. Warwick that on its true construction, although it did apply to past conveyances as well as future conveyances, it did not permit anything that could be characterised as a radical departure, but only a minor departure. What do you say to the submission that he made that demolishing the existing single detached house and replacing it with a block of 9 flats we could decide on the evidence we have, but that would be a radical departure, which I think is one of the things he asked us to do.
So breaking that down, firstly, I don't accept that it could be construed in a way that it could be a radical departure. It's a departure. But assuming that you're against me on that, the answer is, what was the evidence before the master at first instance? The evidence for the master at first instance was simply the planning permission and the planning committee report, and building a development of 9 flats is not a radical departure from a covenant that no building should be erected on the land except one detached dwelling house and stables or garage offices and outbuildings there too. And those are the only facts that we have in front of us. And I think it's the supplementary bundle, about page 130. Actually, no, it's probably... I mean, there's a picture at page 121 of proposed development.
The supplementary bundle.
This supplementary bundle.
Rather bigger than a single house.
Depends how big your house is, my lord, but
well, it's rather bigger than most people's single houses.
And you can see the layout at 124, I think.
Yes. But I mean, the comments.
Oh, I see. Yes.
So there are comments in this. So paragraph 8.16, for example, the last sentence, as outlined above, the proposal would overall result in a development that would respect the pattern and rhythm of the neighbouring area and would not harm the appearance of the street scene.
Those are really planning considerations. Is that the same? Would it be the same considerations?
Well, this is the difficulty. Is what do you mean by radical departure? What would be a radical departure? Are you looking?
No, this is really your submission. You can't construe it that way because there are no touchstones by which you can determine a permitted departure and impermissible departure.
Yes.
Yes. All right.
Thank you.
Anything else?
Did you want to take instructions on the formal position?
Yes. Can I just turn my back for a moment?
Yes.
My instructions are to oppose any application to amend.
Thank you, Mr. Fane. Yes. Any reply, Mr. White?
Well, picking up from the last observation, I do make an application to your lordships to amend the notice of appeal, which I apprehend won't be the formal part of it, because that's simply trying to replace the judge's decision with that of the deputy master, putting the back. It's the arguments in support. So, in other words, it will be amending the grounds of appeal to introduce the additional ground. And so, it's been articulated very clearly by Lord Justice Nugee, so I'm not sure it's helped by me articulating it again. It ought to be done on paper. I'm not suggesting I'm doing it orally. What I would propose is I make the application orally to your lordships on the basis that I would prepare an amendment to the grounds of appeal overnight and send them to probably Lord Justice Newey's clerk, because I think she's been handling the administration, and I would send it to her before 10 o'clock in the morning.
Right. So I'm just looking at the grounds of appeal at the moment, and really it's paragraphs 1 to 5 at the moment, which are your grounds under the judge was wrong head.
Yes.
And so you'll be, what, including a paragraph 5A or something of that sort?
it probably would be 5A.
Well, I mean, wherever you chose to put it, but that's what we might expect.
That is what you might expect, and that's what I was planning to do.
Well, please do let us have what 5A would look like in writing,
Yes.
so that we understand it. But because there'll be no surprises, we don't need to take more time on it now in terms of the amendment, and we'll either grant it or we won't once we've considered that.
Yes. Rather more generally, the learned friend has been commendably brief in his submissions to your lordships. The one particular point that he's said or submitted was that he contends that paragraph 11 are clear words. With the very greatest respect, we submit the reverse. Or if they are clear words, they're clear words from what we contend. But particularly with the deputy master at my shoulder, metaphorically only, I'm not reading any part of his judgment to you, which I haven't done, but my failure to read it should not be regarded as in any way giving it less weight than it commends. As was said earlier in the hearing, the deputy master is very skilled in this area of the law.
Yes.
And he heard the same arguments, obviously with in slightly different form, that you've heard today, because Mr. Fane and I are the same counsel throughout. And he came to a very clear view and different from that which is propounded. So whatever they are, these are, I submit, not clear words unless they're clear in my client's favour. And if they're not clear words, then you use the principles that I've been laying out to decide adversely to the defendants.
Can I just get your submission on the words a bit? So we see in the latter part of paragraph 11, it says, and also reserve the right to allow a departure. Might one think that the word also suggests something distinct from what has come before?
Well, you see, if the first part of paragraph 11 is wide, in that it's any dealing with any of the plots, so dealing is known to be a wide word, then there's nothing so strange with saying, right, well, dealing is, dealing would clearly be, you could sell these plots with no covenants at all. That would be the sort of thing that you'd envisage. And then you might say, well, wait a minute, what about having something you sell a plot, but it's not shorn of all the covenants we've got here, which are those stipulations, independently of those stipulations. That seems to be what's envisaged. So the first part is no stipulations at all, independent of those, but maybe you do sell plots, but they are departing from those. And it's not for me to say what my view is. You've got differing views from the courts below, but there's nothing so strange with saying, right, you can sell all the plots, or you can sell a plot which is independent of the stipulations, or which is departing from the stipulations. And that was the Deputy Master's view, which I commend to you. It's a wholly logical one. And the principles that I've been laying before your lordships is such that, and it's the reverse that I know of what the judge said, is if the draftsperson was trying to do what is suggested, there are so many other clearer ways that could have been adopted. It's not for me to draft the exercise, but only friends the one who says they're clear. We say, unless you're completely with us, then they're not clear. But if they're not clear, then the benefit of the doubt goes on the basis that the specific provisions stay as they are.
And can I ask you one more specific point? So it says also reserve the right to allow a departure. Who would be being allowed by the governors? Who would the governors be? Who would they be allowing to depart?
Well, they would be the people. If the first part is the plot still to be sold off, then you sell them off with perhaps entirely different covenants or stipulations, and then the governors allow a departure from those stipulations.
Well, I mean, on that view, would you need the word allow at all? Reserve the right to depart from?
If you're considering that the owner of the plot for the time being comes along and says, I want to do such and such, you're giving them a permission or a license. So it could be to license the departure or allow it in that context.
Now I'm confused. I probably confused myself. I thought that was what well, take your primary case. Your primary case is that this just reflects what has come before.
Yeah.
And so it's possible to sell land in the future without stipulations.
Yeah.
But why? Who are they then going to allow to depart?
Well,
They just wouldn't impose the stipulations.
well, the second part can be subordinated to the first part, and will reserve the right to depart from. It may be that allow shouldn't be there, but now this is going on to the fallback position. Departure is.
I mean, I quite follow on your fallback case. Allow makes sense.
Yeah.
Yeah.
Yes, I'm very much at risk of repeating what I've said, and I've had most of the day.
Very well. Well, thank you, Mr. Warwick.
Thank you.
Thank you, Mr. Fane. Thank you to those who support you. Interesting argument. We'll take some time to think about this and let you have our judgments in due course in the normal way. Circulation will be to those on the lists. And please let us have your corrections and a draft order agreed if possible, but if not agreed, then with short submissions as to any points of difference. And we'll then make our orders and hand down the judgment electronically without the need to trouble you by further attendance.
Yes.
Thank you very much.
A modern way.
All rise if able.